Hello. How is everyone tonight? I am so sorry it's been another few weeks since we've gone live. We were really trying to go live every week to give updates on what's been happening with my Florida Circuit 7 case and my case as a whole between Florida and Illinois. And I've just been crazy busy writing a lot of legal documents the last few weeks. So since July 1st when we went live, we ended with DIN 229 in my Florida Circuit 7 case. And since July 1st, we are now on DIN 245. So 230 to 245 is what's happened in the last few weeks. There's been a hearing, there's been a lot of interesting things going on. So DIN 230 is my first attempt at alerting everyone that has been doing these things to me in my case, as far as ordering me to pay this outrageous child support fees based off of absolutely nothing in Illinois. Now they're trying to take my driver's license. They've been trying to take my driver's license for over a month now, and I've been fighting them tooth and nail. So DIN 230 is actually my notice of Florida and United States constitutional violations that I filed into my Florida Circuit 7 case and then served to everybody that is violating my constitutional rights right now here in Florida Circuit 7. Do you want to explain that a little bit?
So where this came about, several of the other support groups that we follow have talked about the need to document constitutional violations in your case. And you have to document it as early as possible so that if you need to go to a higher level like the state Supreme Court or the U.S. District Court or whatnot.
For state constitutional violations or federal constitutional violations.
There's documentation that they've violated you.
You've been alerting them and you are aware.
It's real interesting how this actual document came about. Basically, we were able to take Heather's court docket, so all of the documents for her entire Florida case, all as the PDF files, uploaded it into some special software, and it's able to go through, read all of the text, and just by reading the text and knowing the law, it's able to pull out, all various constitutional violations. Now, some of what you get may not fully apply to your situation, so you have to, sort of go through. It sort of gets you started, but everything in here that Heather filed legitimately applies to her case based on the documentation. So there's
due process violations, the 5th Amendment, the 9th Amendment, and the 14th Amendment to due process.
Florida Article 1, Section 2 and 9.
Yeah, 14th Amendment would be familial, being able to have access to parent and raise your own children. And these people are the gatekeepers to my children.
But what this does is it also puts on record the individuals that are causing the constitutional violations, which is they're court officials.
Mm-hmm. They're paid by the taxpayers.
Judges, magistrates, and clerks of the court. And we've had some folks that have other cases in other courts where literally they're having to file lawsuits in federal court against the clerks of the court because the clerks of the court are not following the laws.
Right.
And they're creating more problems.
So this is basically me putting everyone here in Florida on notice to officials. The following officials are hereby placed on notice that enforcement of the April 27th, 2022 Illinois order constitutional ongoing violations of petitioner's civil rights. Judge Stasia Warren, as of June 5th, she is forced retirement because she turned 75-year-old that clearly should not still be on the bench. was the one that signed the illegal contempt order back in November, ordering me to pay my rapist $1,785 a month when I wasn't even employed at the time. I was in the middle of treatments for a car accident earlier last year. Then my current judge, Sandra C. Upchurch, General Magistrate Alexander Alvarez, Hearing Officer Neil Kaufman, and Florida Department of Revenue's Attorney Alan T. Holt. Petitioner reserves the right to file federal complaints under 42 U.S.C. 1983, 1985, and 1986 complaints and related Florida tort claims. Request for relief. Petitioner respectfully requests that the court take judicial notice of these constitutional violations. All enforcement of the April 27, 2022 order be stayed immediately. Any and all further relief as justice may require. And then, of course, I attached exhibits proving that they're violating my rights. So, that's me setting up my federal and state Supreme Court
and
claims.
The violation of rights, there's some of it is very straightforward, cut and dry. When documents are not properly served, that's a due process violation. Mm-hmm. When you're not given an opportunity to be heard on something. So, for example, that November order of contempt, a proposed order was sent to the judge. The judge signed it before Heather could even submit a counter. And then once it was signed,
the hearing notes from November 5th with Judge Stasio Warren literally say petitioner has 10 days to provide her financial affidavit because I can't hold her in willful contempt if she's not in willful contempt. And I wasn't, because I wasn't working for all of 2024. After I got laid off, 2 weeks later, I was rear-ended by a Corvette and shoved into two cars in front of me. So that's not my fault. I didn't choose that. So I'm not in willful contempt, and yet Warren signed it the same day it was emailed to her and completely bypassed my due process. Didn't even look at my financial affidavit. So I have in hearing notes saying that I had 10 days to provide my financial affidavit to Justin Serlick's attorney, Serena Baldacchino of Rice Law Firm, and 10 days to the court. And then I also had 10 days to submit a proposed order. My 10 days weren't given to me. They signed it before the 10 days was over. So I'll deal with that in federal court, I guess. So DIN 231 is the notice in appellant court served into my file stating that my appeal was dismissed. And that was my motion to vacate the Illinois April 27, 2022 order here in Florida, because Florida technically has jurisdiction to vacate it because they had jurisdiction at the time that order was written.
It definitely gets complicated to track some of this, but if you slow down and actually go step by step and follow what the law says, the reality is that order from Illinois was illegal on a number of fronts. It's not even just the jurisdiction. There was other significant issues with that.
I wasn't present. I had no attorney present. There's no due process. No certificate of service.
We're gonna talk about that separately.
There's a lot of problems with that 3-page order that my ex-husband is hiding my children behind, and it's only a matter of time before it goes away. Bye bye. So DIN 231 was Florida District 5 Court of Appeals dismissing my motion to vacate that Illinois order down here in Florida. When Upchurch denied it, I turned around and filed a notice to appeal it immediately and got it in appellant court. And then they served me with a request to show why they should keep it and not dismiss it. And I gave them the exact reason they should have kept it, and they dismissed it anyways. So that led me to what I did next in Illinois, and we'll get to that. It's
weird with the appellate courts, too, because it was confusing at first because they accepted her reason, and then they denied the original appeal.
Well, it was dismissed. Dismissed. It wasn't even worthy of reading. DIN 232 is motion to dismiss respondent's motion to vacate. So this is all in regards to my driver's license being suspended for these arrears that they are forcing me to rack up with my rapist, Justin Serlick, while he withholds any and all contact. So this is Upchurch.
No, this was the Department of Revenue.
Oh, yes. Thank you. Okay, yeah, so this is Alan Holt trying to dismiss my motion to vacate the suspension of my driver's license, trying to argue that the transcript that I provided was not certified.
So let's break this down for just a minute here. He's not arguing that it shouldn't be vacated because they didn't have jurisdiction and it's when it was issued and it's wrong to enforce it. He's arguing a technicality that a transcript didn't meet the specific standards. Now, to get an official transcript in Florida, you have to, or an official transcript, it has to be certified by a certified court reporter. Basically, you have to go out and find a court reporting company on your own, pay them to transcribe the official recording, and then you enter the transcription. It takes time to get. This all had to be done within, I think, 10 days. So the initial transcript that we submitted was an AI, transcript by the computer with a note that said, Heather reserves the right to submit an official certified transcript as soon as one becomes available. So
keep in mind this was 4th of July weekend.
This was the attorney for the Department of Revenue filed this on Friday or Thursday.
July 3rd. July 3rd, right before the 3-day weekend. Basically
trying to just get the whole motion to vacate dismissed.
Yeah, it's so clear that Alan Holt is working for the Serlicks.
Well, what they weren't planning on is we were actually in the process of getting a certified copy. And we did.
We filed it on July 4th. So
Heather filed a response to Alan Holt's motion to dismiss, and the response included the certified copy.
Now, so we'll get to that. You're fast forwarding. We've got some questions here. So all the same people I'm suing too, we need class action against them. Absolutely. That's why I'm running these podcasts, to get the word out to the general public that if you are a victim of any of these people I'm naming, these bad actors that are stealing from taxpayers to walk all over our constitutional rights, come forward. Absolutely, come forward. The more victims we can find of these people that I'm naming by name, the easier it will be to sue them in federal court. So absolutely, agreed. Did Clerk Sandra B. Williams dismiss? That is a good question. I don't know. This will be available when I upload it to YouTube to click on it and read it. But what it says, hang on. What it says, upon consideration of appellant's response filed June 25th, 2025, it is ordered that this appeal is dismissed. It is further ordered that appellant's motion for consolidation filed June 13th, 2025 is denied as moot. I hereby certify that the foregoing a true copy of the original court order. And then Sandra B. Williams' stamp is right below it. And then right below her stamp, it says panel, Judges Edwards, Eisnagel, and Harris. CC to Heather Bendl, Volusia Clerk, Justin Derek Serlick. So I don't know. That's a great question. Because I really feel that what's happening in my Florida Circuit 7 case is the judicial assistant for Upchurch is just slapping a denial on it the moment it gets filed in. Because I find it very hard to believe that Upchurch is actually reviewing my documents in the moment and denying it immediately. So that's a great question. I don't know. But we'll find out eventually when I get this in federal court. And then Alan Holt is a joke along with Neil. Yep. Alan Holt, if you look at that 15-minute hearing
couldn't even look at Heather
on June 17th, could not look me in the eyes once. You see his foot. He's shaking his foot. It's clear he was nervous. It's very clear he's an introvert. And I can't wait to see him in federal court because I'm going to destroy him. So yeah, this was him right before 4th of July, trying to get Judge Upchurch to dismiss my motion to vacate, mainly because there was a hearing scheduled for the following Monday, July 7th, and he was trying to get it dismissed, so I couldn't even be heard. So there's my due process being walked all over again, where he was trying to get it dismissed.
To get it dismissed on a technical, issue, that
Per clerk's attorney today, they're under investigation for the mail fraud using Diane Matosek's name as a deceased public official. Nice. Yeah. That whole situation here in Florida Circuit 7 is interesting. That
we have dead clerks of the court
are being sent to U.S. citizens in Volusia County with a dead clerk's name on it.
And it's not like she just died yesterday.
Years ago.
Years. Like 2018 dead.
So there definitely needs to be an audit of the Florida Circuit 7 courts. All right, so DIN 233, Tiger's getting in the video here. 233 is my verified response in opposition to motion to dismiss respondent's motion to vacate. That's a mouthful, but it's literally me filing a response to Alan T. Holt's motion to dismiss my motion to vacate the driver's license suspension. So this is the hearing where I gave the certified copy of the transcript on June 17th, where I'm literally just saying, you're violating my rights. This is a void order. You're violating. This order is not even registered in the state of Florida properly.
Yeah. So now the hearing. So this was filed. I think you filed it on Saturday.
On July 4th at 2:50.
So on Friday, this got filed. The hearing was already scheduled for Monday morning.
Right.
Hearing starts Monday morning. And we don't think the judge had seen Heather's response because they were trying to play it off as if the transcript Heather submitted wasn't certified.
Exactly.
And when Heather tried to explain she did submit a certified copy, they said, well, they just passed it off again. And it wasn't until the judge's actual final order on it where the judge actually said, we're not going to take time to figure out whether or not that company
the recording of that hearing on July 7th is on my YouTube. I recorded it with my dictaphone in the event that if I could not get the proper recording, I would have a recording. And of course, I paid the $22 to get the recording properly through public records on Florida Circuit 7's website. And then I get an email back saying, we couldn't find a recording for that. We're going to issue you a refund. Of course, we couldn't find a recording for it. Why would they record themselves walking all over my constitutional rights? So, my nonprofit, Justice for the Serlick Children, recorded it instead. So that can be heard, not seen, but heard on my YouTube channel as well under the, it's the playlist for the hearings specifically. And then DIN 234 is literally the hearing notes from that. Why don't you just read the hearing notes, because they're always a joke.
So they use special symbols, pi and delta. Pi would be petitioner, delta...
it doesn't matter.
The opposing party. Attorney Chelsea Abum, present for DOR.
Yeah, so Alan Holt was not present on the 7th.
They flip-flop attorneys.
Yep.
So you don't even get to...
And this woman was literally...
She was just handed the case that morning.
It sounded like she had her microphone in her mouth. Yeah. I could not understand most of what she was saying.
Let's see.
Yeah, see, it doesn't even have anything.
Court ad re motion. I think it's supposed to mean court addressed regarding motions to
stay driver's license.
Okay. Petitioner's motion and DOR's motion. Court ad and denies DOR's motion to dismiss. So ultimately, the judge denied the Department of Revenue's attorney's motion to dismiss, and they proceeded with the hearing because they realized at that point, finally, that
I had a certified copy
Heather's
filed.
Transcript was the actual judicial rule says it has to essentially significantly comply with the rule, which it did.
Yep. It was a certified transcription. I'm not going to use their little racketeering circle people local. I'm not going to contribute to the problem. I will pay someone out of state to do it.
So here's something interesting to know. If you request a court reporter to be in the hearing, so in Heather's case, she requests it as part of her ADA accommodation so they get CART services. The court reporter that is provided through CART services works for a company called, what's the name of the company?
Are you talking about Esquire?
Yeah, Esquire.
Esquire Services. Yeah.
So Esquire Services is the court reporting company for Circuit 7 Court.
Paulita Cundiff.
However, if you, as a pro se person that has a case in Florida court, contact them directly to find out about getting them to transcribe your documents. And I have the email. I'll send it to Heather because I was helping Heather with some of the logistics here. I have the email from them where they say, "Oh, we don't work with pro se people at all." Okay, so if the one service that the court recognizes doesn't work with pro se, how's a pro se person supposed to get transcripts? Well, the other local company is privately. There's a few private companies.
You like $1,000.
And yeah, it's upwards of $1,000 per hour.
And that's intentional because they know we need it to get the stuff on the record.
So
this is intentional blocking of court reporting and court transcripts, so we can't go after them.
So
it's intentional.
There's various online services, and you can get an AI court legal transcript done for like $20 to get a certified copy on a rush level. It was about $130 to get this little 15 to 30 minute hearing transcribed with a certified transcript. And we did it and got it submitted, and so they really couldn't say that Heather didn't
they just
properly.
don't like that we're not using their little racketeering people locally. We're not supporting the RICO. They're not happy with that. Too bad. DIN 235 is my record on appeal to the District 5 Court of Appeals, so that got sent over properly this time. And then DIN 236 is verified motion to contest driver's license and motor vehicle registration suspension. Yes, all over again, because I got another letter in the mail from Florida Department of Revenue saying you have 20 days to take action or your driver's license is going to be suspended. Well, I took action this time, all right? This time I loaded it up with even more
And we
evidence.
don't know if that was meaning they were going to suspend it a second time or
no clue.
If their
but that
system
motion
is just messed up.
that big. All these yellow sheets you see, those are all exhibits. So this is 3 times the size of the motion to contest driver's license I filed back in May when this all first started with my driver's license.
And what are some of the examples of some of the exhibits? Just you don't have to go through the details. Just read the cover page.
So like Exhibit A, February 28th, 2022 and April 27th, 2022 Illinois orders, literally ordering me to transfer the case to Florida and proving that Illinois did that 3-page order illegally, which has been my argument the whole time. The supplemental petition for modification of child support showing how long I have been trying to modify my child support that shouldn't even be there to begin with. Because they're literally denying me the ability to modify the 785, which is completely illegal.
Yeah.
It's illegal in Florida and federally. And then the July 16th or January 16th referral to general magistrate showing the modification of the child support. There's a ton of stuff. A lot of it we've already gone over. It's just me once again putting it in their face.
If you read the actual Florida statutes on modifying child support, it says that essentially if you're in an involuntary situation, if your life, something changes involuntary, meaning you didn't control it, and
like
it affects
a car accident that made me unable to work for a year.
You're supposed to have an opportunity to make an adjustment.
Yep.
The Department of Revenue sent Heather a letter basically saying, "Yeah, we're not gonna help with you because it's voluntary." Yeah. So Heather chose apparently to be hit by a car with no insurance.
I wasn't cleared to return to work until January of this year, and that's when we finally settled the case. And I didn't get anywhere near what I was originally told I would get from my attorney.
Let alone what you were. You're essentially out a year of wages.
Right.
So you didn't even recover what you could have potentially made had you been working.
No,
and
it
instead
was
you spent hours.
Geico ran me in circles for almost 5 months in regards to that claim. So basically, the settlement of my car accident did not come from the person that hit me. It came from Pete's insurance that was covered for underinsured motor vehiclists. So we were actually trying to get the settlement from his insurance, not the person that actually hit me.
Because it was my car. Heather was driving.
Right.
My car got totaled.
Yeah. So, but it was a very bad car accident. That Corvette ended up underneath me, completely underneath me. I was on top of his Corvette. And then he yanked his Corvette out from under the car and dropped me to the ground after shoving me into 2 cars in front of me.
It
was
gave
bad.
Heather some herniated discs in her back.
I ended up with 2 herniated discs, 3 bulging discs. I had a concussion, a severe concussion. So even if I did still have my job at Intuit, I wouldn't have been able to work because I was working with people's taxes. And when you're working with taxes and payroll, you have to be 100%. They're forcing me to rack up all this debt with Justin when I could not physically work last year. Then DIN 237 is motion to supplement. So what this was, my record on appeal, when I sent over the directions to the clerk, I very clearly instructed them to send over my entire docket to District 5 Court of Appeals, the entire docket, because my entire Florida docket tells this story, which is why we're explaining document by document what's currently happening. It tells a story. It shows what's happening. I get my record on appeal. I'm starting to write up my initial brief, and I start to realize that 2 very, very important motions that I filed that were part of the appeal were missing from the record on appeal. One of them was my motion to disqualify Judge Upchurch, and the other one was the motion to vacate the Illinois order. And those 2 motions were incredibly important to my entire initial brief. So I filed a motion to supplement into my Circuit 7 court case with another directions to the clerk. The above directions were timely filed June 10th, but the 2 main motions for this appeal are missing from the record on appeal, DIN 167, May 8th, 2025 motion to disqualify, and DIN 194 motion to vacate Illinois order. These 2 orders should have been included on the record of appeal from July 7th, 2025. DIN 167 is the motion that triggered appeal case 1442 that was now consolidated into case 1056. So it must be included regardless of the directions the clerk states. When I called Circuit 7 Appeals Department, they said they tried to send it over to District 5 Court of Appeals and they rejected it. Why would they reject certain portions of my record? So I supplemented those with my appendix to my initial brief instead. And then DIN 238 is order on Department of Revenue motion dismissed. So like what we were just talking about, Upchurch on the 17th last week had put in 2 orders after my writ of prohibition in District 5 was dismissed. So she clearly was waiting on that writ to be dismissed before doing anything.
Legally, she's barred from taking any action when there's a pending writ of prohibition.
Right. So this is what she supposedly wrote. And again, I'm not even convinced that this is Upchurch's words. I think this is the JA. This cause has come before the court for hearing on July 7th upon the Department of Revenue's motion to dismiss petitioner's motion to vacate docket number 277. The court being fully advised in the premise finds and orders as follows. The court has reviewed the subject motion and is treating it as the Department of Revenue's objection or response to petitioner's motion to vacate. The department's arguments regarding the transcript's compliance, family law procedure, Rule 2.535, Florida Rules of Judicial Administration, are well taken, except that arguably the non-compliance may well have been remedied with the petitioner's filing on July 4th. 2025 of a response to the Department of Revenue's motion to dismiss, which response docket 233 attached what may be a rule-compliant transcript. In an effort to offer petitioner the benefit of the doubt and spare the court, all the parties, a deep dive, in quotes, into whether ditto transcripts in Denver, Colorado is indeed an approved court reporter or an approved transcriptionist, the Department of Revenue objection to said transcription is overruled. As guidance, the court will remark that the transcript initially filed with the motion to vacate at docket 277 was certainly non-compliant with the court rules cited above. In the future, the parties in this matter should be prepared to present the court arguments for and against the propriety and compliance of transcripts such as the prepared by ditto transcripts and other similar organizations. So basically, she's saying use our racketeering people.
Which, here's the thing.
Use our people.
If you go on... This is the other crazy part.
They're part of our RICO.
The other crazy part of that, you go on the Florida Circuit 7 court website, and they literally say, we can't give you a list, and we're not going to tell you what transcription services to use. Mm-hmm. So you're literally on your own to find, and so you go, it's Google search.
And then when you find it, they complain about it, as you just saw. And then the next one, DIN 239, is order denying petitioner's motion to vacate. So all of that just to do what she does to everything else, deny it. But
this is one of the first times she actually
this is the second time.
Second time. She's starting to put
except
reasoning.
she's completely wrong.
Just flat out wrong.
Wrong.
Just basic
either
law
she
is
really dumb or she thinks I'm this dumb. I'm not. I'm able to research. I'm a damn scientist. I'm able to research for myself. I don't need a judge to tell me what is and is not the law. It's so clear from the moment I met her, she doesn't know how to do her job. I'm not familiar with that Florida statute, therefore I'm denying your motion.
Yeah,
an emergency custody motion to pick up my children.
Not going to take 2 seconds to look it up on the computer that's sitting right in front of you, but just deny it.
But guess what? I now have some of Upchurch's victims that have filed 12.941D, a motion for emergency custody. So she has absolutely seen that motion before.
Yeah.
So she just flat out lied to me to my face January 8th at the very first time I met her. So anyways, this is her denying my motion to vacate. This cause has come before the court on July 7th, 2025 upon petitioner's motion to vacate child support hearing officer Neil Kaufman's recommended order regarding driver's license suspension, docket number 227. The court, being fully advised in the premise, finds and orders as follows. All parties were present for the aforementioned hearing. An argument from all parties was heard. If you listen to it, no, it really wasn't heard. I was not heard at all. They were not listening to me. And that's why the recording is on my YouTube for the whole world to hear.
They kept talking over Heather and then basically saying,
I'm not allowed to object.
We're not gonna listen to any of your complaints.
I'm not allowed to object to the attorney who is trying to take my driver's license. When you're pro se, you act as your own attorney. And if your own attorney is not objecting to things, he or she is not doing their damn job. So they're literally telling me as a pro se litigant, I'm not allowed to object to the other side. Bullshit. Bullshit, bullshit, bullshit. If attorneys can object, then I can object because I act as my own attorney. They would not allow me to present my argument, and it's become very clear. It says, petitioner failed to identify for the court any error committed by the child support hearing officer in his June 17th, 2025 recommendation to the court that petitioner's driver's license be suspended unless $1,000 was paid within 30 days. Petitioner argued, as she has on many prior occasions, that the out-of-state order requiring the payment of child support is void ab initio, therefore unenforceable. This argument is untimely and not persuasive. The time to challenge the propriety of the April 2022 out-of-state order has long since passed, and indeed, petitioner initiated this cause of action in Florida in August of 2023, seeking to have that very order registered and or domesticated and therefore enforced.
Okay.
Hang on. It gets better. Petitioner's motion to vacate is denied with prejudice. Done and ordered.
Okay.
Let's talk about that.
So much to dissect there. So, well, first, let's just hit the elephant in the room. The timeliness of objecting to the void ab initio nature, or a void order can be attacked at any time. That's not just Florida law.
It's Illinois law.
It's Illinois law. It's federal law. Okay, there's U.S. Supreme Court law. A void order is a void order attacked at any time.
No court order is ever permanent.
So,
they can always be modified or vacated if the grounds for it is there.
So, now, yes, it is true that Heather initiated the action in Florida through her attorney. What
does DIN 1 say in my docket?
So what you're wanting me to tell you is that it specifies it's to register it for non-monetary.
Non-monetary.
Okay.
You hear that, Mary Serlick, Ira Serlick, Justin Serlick? It literally has checked non-monetary.
So
you guys failed to ever register it for monetary.
That's on you. There's other issues with it too. That we've found that as we've been doing the research on basically going back through Heather's case from start to current, there are specific rules that you have to follow to register a child. There's differences between a child support order and a child custody order.
Yep.
There's
some
extra requirements for child support orders. One of those requirements is that for it to be properly registered, there has to be a sworn statement of arrearage at the time of registration. There was not. So this is another error on the Florida courts, because if they're accepting that registration, then there can't be any arrearage charge from the moment they accepted registration and prior.
It sounds like they got shafted by Serena Baldacchino, and Serena didn't actually do her job except illegal activity with the contempt order in November, and Serena's going to be sued by me.
So,
so moving on.
Yeah. There's a lot more to that where the judge was just wrong in her legal theory.
Yeah. So that once again triggered me to do what we'll touch on in just a few minutes. DIN 240. Notice of appeal. So that was literally slapping a notice of appeal on this denial immediately, and getting that over to District 5, and getting a new case. So DIN 241 is my indigency form, waiving the $100 appellant fee to get a new case in appellant court. DIN 242 is the registered indigency form that they waive the $100 filing fee on. And then DIN 243 is my notice of my new appellant case on that most recent denial of the motion to vacate the suspension driver's license. And then acknowledgement of new case is DIN 244. So within a few days, 3 days of her denying my motion to vacate the driver's license suspension, I've already got a new case number for my appellant case. So that is case number 5D 2025-2188. I'll just keep appealing it until I get it to Florida Supreme Court. Not a problem.
The interesting thing with that case is because it's one of the first times she's given like a full detailed written findings, and her written findings are just flat out legally wrong.
So it gives me plenty to write about in my initial brief for just that.
The appellate judges should look at her, literally just look at her writing and say, wow, she shouldn't be a judge. We have to take action now.
Yeah.
So
then my last one, which was just yesterday, the 22nd, DIN 245, is directions to clerk for that brand new appeal. And I made it even more clear in this directions to clerk what should be included. Petitioner/appellant Heather Louise Bendl directs the clerk to include Heather Louise Bendl's entirety of her Florida Circuit 7 case 2023-31828 FMCI docket, which consists of DIN 1 all the way to DIN 245 from the record described in Rule 9.200A1. This is to include all hearing notes, motions, orders, denials, exhibits, motions for emergency custody, Judge Stasio Warren's self-recusal, both motions to disqualify Judge Sandra C. Upchurch, motion to vacate 2022 Illinois order, and any other filings to date as of July 22nd, 2025. This case was opened by Heather Bendl August 7th, 2023 with DIN 1, and as of the date of this direction to clerk, July 22nd, 2025 is on DIN 245. All DINs between 1 to 245 must be included. This form is timely and otherwise properly filed before the court. So yeah, there we are with that. So even though I already have an appellant case going that I just filed an initial brief on, now I have a whole new one just for my driver's license suspension. And so that's all caught up on Florida Circuit 7. So we're going to transition to my initial brief for my District 5 Court of Appeals.
And we learned a lot
yes, we
going
did.
through
yes, we
just
did.
the process to prepare this. We're actually going to do a whole separate episode. We're going to try to make it a little fun and lively on just the some of the technical issues and just some of the weird stuff that the hoops you have to jump through to be able to
so in
something.
total, your initial brief cannot be more than 50 pages. I got everything I wanted and needed in my initial brief, and I'm very proud of it, in 48 pages. It may look like it's more than 48, but actually
the table of contents,
the table of contents,
don't count.
table authorities, none of that counts. So it really starts counting.
So it's really probably about 40 pages of...
No, it's 48. Oh. It starts counting on statement of the case and facts. So in appellant court, there's required sections that your initial brief has to have. So how I did this is I just laid out all of my sections and titled them, and then just started filling in each of the sections individually. So we kind of picked it apart in sections. So this will be a separate link on my YouTube channel for this podcast episode. So there'll be 2 links to documents. One will be the DIN 230 to 245 that we just went through in my Circuit 7 docket. And then the second link will be my appellant's initial brief. I've sent it to quite a few of my friends, because I'm proud of this. This was my very first initial brief. As a writer and as a scientist, I'm not used to doing these legal writings, so this is all really new to me. So I'm kind of proud with this. At first, I was really intimidated by it. I could not figure out how to do the sections properly, and then when I started really sitting down and picking it apart, it actually became a lot easier to understand. But basically, the end of this brief, what we're asking them to do, it gets the conclusion.
Yeah.
So all initial briefs have to have a conclusion. And I'm just going to read the conclusion. I'm not going to read all 48 pages. You guys, if you're interested, can take a look at the entire initial brief. Especially if you're getting to the point where you need to write your own and you need to see some samples. This was accepted and approved, and now it's in the process of being reviewed. So I must have done something right because it was accepted. For the foregoing reasons, Appellant Heather Louise Bendl respectfully requests that this honorable court reverse the rulings of the 7th Judicial Circuit in case number 2023-31828 FMCI and remand with instructions. 1. The trial court enter written findings confirming or denying subject matter jurisdiction under the UCC JEA and UIFSA consistent with, and then the statutes, and if jurisdiction is lacking, to vacate enforcement of the April 27, 2022 Illinois order. 2. That the trial court deem the April 27, 2022 Illinois order void ab initio and unenforceable in Florida for lack of jurisdiction and failure to comply with registration procedures. 3. that appellant's motions for custody and temporary time sharing be treated as initial proceedings, not modifications, and be heard with full evidentiary proceedings and written factual findings. 4, that the court be directed to make statutory best interest findings under 61.13 Florida statute, including inquiry into the children's current condition, safety, and emotional health. This is important, right? Circuit 7 should be concerned. If one of the parents is saying they're very concerned about their children's emotional, educational, and physical health, the judge should be ordering Justin to provide proof that I'm wrong.
And that's one thing. That's one thing that was just so strikingly missing from all of the hearings. The judge has never asked, not even the general magistrate, how are the kids doing? When Heather pointed out that they're failing miserably in school, the judge did reprimand Justin that she was concerned about.
Behind my back. She couldn't even do it in front of me. She waited until I left the courtroom to castrate Justin.
Right after he was reprimanded, like the very next day, they moved one of the kids into a different school.
And I've lost all access to his grades now. And that would be my son, Thomas Serlick. So I advocated for him, even though I have no access to him whatsoever. He was moved to a different school. I happened to notice that Richard Milbourne Academy, he was unexcused, absent, nonstop as well. And then about a week later, I lost access to his records and his attendance. So go figure. And then 5, that this court direct the lower tribunal to remedy procedural and constitutional due process violations, including those stemming from ADA noncompliance, unequal treatment, and improper ex parte communications. And that would be with Michael G. Nurheim. 6, that any ongoing enforcement of child support or visitation restrictions arising from the April 27, 2022 Illinois order be stayed pending proper adjudication in compliance with Florida law and constitutional protections. Additionally, appellant respectfully requests that upon remand, the case be reassigned to a different judge within the 7th Judicial Circuit, as the continued presiding role of Judge Sandra C. Upchurch presents a constitutionally impermissible appearance of partiality. Judge Upchurch has failed to adjudicate threshold jurisdictional challenges, denied hearings on urgent and substantive custody matters, and issued adverse rulings without factual findings or adherence to procedural safeguards. Her conduct, marked by disregard for statutory mandates, failure to rule on pending motions, and tolerance of improper ex parte communications, undermines the fairness of the proceedings and erodes public confidence in the judiciary. Disqualification is warranted under Canon 3E1 of the Florida Code of Judicial Conduct and Rule 2.330 Florida General Practice in Judicial Admin to ensure impartiality and judicial integrity. Reversal is required to uphold Florida's statutory mandates, prevent further deprivation of parental rights, and ensure that custody determinations affecting Florida children are made by Florida courts exercising lawful jurisdiction. Appellant has suffered over 3 years of separation from her children due to unlawful enforcement of a void order. This court's intervention is necessary to restore due process and prevent further harm.
One thing I do want to point out with that, it did talk about the ex parte communications. There's actually at least 2 that we have documentation on. It's not just, Heather's mentioned several times this email from her first Florida attorney that documented a phone call from one of the judges in Illinois, who wasn't even one of Heather's judges. He's a judge in the circuit up there. But there was another
He was the state attorney that was responsible for prosecuting Justin Serlick in September 2020, when my children and I told the investigators what Justin Serlick was doing to us.
So the other ex parte communication that the current Judge Upchurch has just allowed was actually Justin's mother emailing the court and getting
the judicial assistant
getting that email docketed essentially into the case,
which is literally completely illegal. It's illegal.
It's an ex parte communication. The clerk should never have.
A non-party member should never be able to get anything in my docket.
So that
only Justin and I and any other entities involved should be getting things put into my docket.
That basically, whether or not the judge even looked at it, the fact that it's in the docket and can be seen, it's essentially ex parte communication. The judge hasn't reprimanded Justin for having his mother send it in.
Why would she? They're all friends.
The judge hasn't never acknowledged it officially, which is basically permitting it to, who's to say it won't happen again? So really,
which is why we're putting all of this under a microscope for the entire world to see.
So, and who knows? There could have been other stuff, but those are the two instances where we have document uncontrovertible
So
proof.
obviously, it's clear that even though Florida had jurisdiction as of February 13th, 2022, Justin was a legal resident of Florida. His driver's license was Florida. I was a legal resident of Florida. My driver's license was Florida as of February 8th, 2022. And then as of February 13th, 2022, my 3 youngest children were physically living in Florida for more than 6 consecutive months. Illinois should have never touched anything moving forward after that in regards to those 3 children.
Especially after in February of 22, they issued an order to transfer the case to Florida. So once they issued the order to transfer the case in Florida, that was them essentially acknowledging that Florida had jurisdiction to handle it.
They cannot make custody decisions behind the scenes when neither parent is a legal resident of Illinois.
Yeah.
What?
Yeah, or at least when you live, back up. Once you move more than 25 miles outside the state border of Illinois, it's actually Illinois statute. As soon as you move outside that 25 mile range, the state of Illinois, by their own statute, does not have jurisdiction. Period. End of story. Yep.
And that's Illinois' law too. So it's not even just a Florida law.
No, that's what I said. It's
Illinois. An Illinois law. Yeah. So that brings me to touch on what we are going to touch on in a different episode altogether, because we have not been able to go live in a few weeks because we've been busy writing all these legal documents and trying to take some mental breaks from it and try to do things on our own for us around the house. We power washed the pool patio, getting the pool up to chemical standards so we can actually swim in it for the first time this year because we've been so buried in this crap. But obviously, I've kind of shown all of you that no one in Florida will touch this Illinois April 27, 2022 order. So that has pushed me to what I have now done as of last week. As of July 18th, I have now gotten on my Illinois docket a petition for relief and vacatur of the Illinois 2022 order. That petition throws a lot of people in Illinois under the bus by name, because I will absolutely be using that to move it up in Illinois Supreme Court. So I'm setting my federal foundation now and throwing everyone under the bus, including manipulations to my Illinois docket and things that showed up in my Illinois docket June of this year.
Literally,
things that happened last year.
While we're preparing this, we noticed there's all of a sudden a random new entry that purported to be notes from a hearing from September of 24.
And they're completely wrong. Yeah. And it's literally making it look like Justin was awarded full custody, fair and square, and that's just the way it is. No.
These notes, it doesn't show who put them in or even who drafted them.
There's no name on it whatsoever.
There's just it is incredibly shady. It's the clerk's letterhead or the court's letterhead and some notes, and they don't even match the actual motion that the court had filed back in September.
Aaron Cartwright Weinstein, like I told you in an email and private message, you've got some problems in your clerk's office. My docket is being manipulated by people in your clerk's office that you are responsible for as an elected official. And I do appreciate your assistance on Friday the 18th. However, there does need to be an investigation into your clerk's office and what they are doing with my docket and why things are just randomly getting filed into my docket through your clerk's office. So I'm calling out Aaron Cartwright Weinstein, the elected official of Illinois Circuit 19 Clerk's Office, for an investigation into what is happening with my docket and the illegal activity. So that's on you to get investigated. And then in another episode, we're also going to talk about my writ of prohibition that I've now had to file twice in Florida District 5 Court of Appeals. We're trying to keep these episodes on the shorter end, so we're going to split all of these documents into 2 episodes. So we'll probably go live again Friday evening to talk about the Illinois petition, my Illinois court date, which is August 12th, via Zoom at 9 a.m. Central Time, 10 a.m. Eastern, where I will be presenting all of this to my Illinois judge, Judge Melius. I have never seen or spoken to her before, other than when she was shortly in this UCC-JEA conference, September 3rd of last year. I'd never seen her before. She was reassigned to my case from the original judge, Marnie Slavin, who signed this Illinois order back in 2022, just before she was involved in a murder-suicide in Buffalo Grove.
Where she put in an order lifting an order of protection, and then the husband showed up, killed his wife and kids.
Yep. So if you Google murder-suicide in Buffalo Grove, Illinois, so 2 words, Buffalo, like the buffalo, and then Grove, like flower grove, Illinois, you will find a whole slew of news articles and news conferences in Chicago on this murder-suicide that happened. What you will not find in any of those articles is the judge's name. Yeah. That is because they quietly moved Marnie Slavin off of family law and onto other things. So I think she does like criminal now or something.
Now she's on the juvenile dependency.
Yeah. So she got moved off of my case for that murder-suicide that happened in late 2022, because it was about 6 months after. Yeah, that murder-suicide happened about 6 months after she signed this 3-page order. And so she's still sitting on the bench in Illinois Circuit 19, just not on family law anymore. They quite literally silently pulled her from family law.
And there's if you read, see the different news articles, there was a lot of suspicion that court notes and documents were altered after the fact to try to cover something up. Basically,
imagine that. Just like happening in my case with her order she signed in 2022.
There was apparently handwritten notes on several of the court documents to try to say, oh, everybody was in agreement with lifting this order, but there's no proof that there really was.
Nope.
And it's interesting that they allow handwritten notes on typed orders. Heather actually has that with her Illinois docket. Just handwritten notes on the case is closed in December. All of a sudden, a new thing gets filed in January saying with another checkbox checked, and then everybody was in agreement. Have a nice day.
Here's the crazy part. Even if they changed, so the manipulation, which I covered quite a few episodes ago, the manipulation of my court records, changing the date that the Illinois DCFS case was closed out, the actual proper date it was closed out was December 14th, 2021. Okay? They then went in and modified that to saying it was closed out like January 26th of 2022. If they did that in an attempt to get them to still have jurisdiction, it didn't work, because the jurisdiction goes off of when the kids were physically placed in Florida. They were physically placed in Florida August 13th of 2021.
6 months later, February 13th, 2022.
Exactly. So regardless of their manipulating of when that case was closed, it does not change the UCC-JEA rules that 49 of the 50 states follow, and that is 6 months.
And then so there's part of the UCC-JEA is if proceedings had already initiated, they retain continuing subject matter jurisdiction. However, that's not automatic and guaranteed, and there's specific, like we mentioned already, specific provisions in Illinois statutes where they automatically lose jurisdiction.
They have no jurisdiction when both of the biological parents are no longer legal residents of Illinois.
And the children in question.
I'm sorry I screwed up their plan by converting my driver's license, but I actually did that by the suggestion of my previous attorney.
Who told you to
Thomas
get your
Hunter
butt
told
to
me
Florida
to
as soon
take
as
that
possible.
RV down to Florida, become a Florida resident as soon as possible, and hire a Florida attorney. And I did just that. So it was so obvious that Attorney Thomas Hunter knew about UCCJEA, but he was not telling me exactly what he knew, but he clearly knew enough to tell me to transfer my Illinois driver's license to Florida as soon as humanly possible. So obviously there's illegal activity. And that's why we're continuing to keep everyone in the loop on my story, because this is happening. This situation, as crazy as it sounds, is a lot of people's stories across this nation when it comes to multiple states.
We're getting, honestly, it has been shocking for both of us, as we've both at this point now been connecting with other people dealing with family court issues across the country. I do want to say we are getting our podcast going. I know we've talked about that. We did have to, or I had to get some permissions in place, but we've gotten approvals. Everything's good to go on that front. We'll be fully starting the interview podcast
next week. Now that all of this is out of the way, I really need to focus on these large documents and get them filed. Now that they're filed, we can actually start focusing on our podcast. So I have my podcast, Disrupt the Corrupt. Disrupt the Corrupt is all about bringing other victims onto the podcast and giving them a platform to tell their story. Justice for the Serlick Children nonprofit podcast is to tell my story, my experience, Pete's story, Pete's experience with my children's crazy situation. And then his podcast.
I'm going to be hosting the Support Isn't Silent podcast, and that's going to focus on other people like me who are the spouses and partners of victims of family court issues, and we're sort of telling our stories, which you don't hear about that often, because everybody really is focused on the victims, but the reality is, even though they're not my kids,
he's going through it.
They're, to some extent, I'm also being victimized by the family court system at this point.
We've been together for 2 years. Have you been able to create any sort of bond with my children whatsoever?
No, I've met two of them. So we took Ariana to a hockey game. We took her and her boyfriend to a Orlando Solar Bears hockey game. And for the most part, that was the first time you had seen her and she saw you in a couple years. It was a little awkward, but generally a pretty good day. So it doesn't really make any sense how things are now between the two of you. And then I was
5
with you.
years of alienation. It's 5 years of her being lied to by Justin marrying Ira Serlick. And Ariana, I pray someday you actually take the time to look at all this evidence and realize that all of these trusted adults have been using you, have been hurting you. And she deserves to know the truth.
I went with you when you went to your youngest son Charlie's school, and we were able to meet with him in the guidance counselor's office. And he's a cool kid, and what he knows about the situation, he was 3 when this started. He's going on 8 now. 9. He's going on 9 now. He 100%, we didn't tell him anything. He knows what's going on. He knew who was really responsible for things. He knew who was responsible for Heather not being able to, or for him not being able to see his mom.
And he said that in front of Principal Karen Troutman and Counselor Emily Sweet at Palm Terrace Elementary last year. It's it's appalling that the court system is structured in a way to allow this stuff to drag out for so long. And we've been sitting here thinking, this is essentially over 5 years from when Heather's situation started, and there's no resolution in sight. Well, there's another activist that Heather has been following his movement, Dave Weigel. He just finalized his divorce, 14 and a half years in New York court system to get a divorce. 14 years. I think he was in court longer than he was married. Yeah, it's insane. And even though they gave him the divorce, they tacked on an insane amount of support he has to pay per month. Very, very similar to what they're doing to me.
Yeah.
Ordering me to pay my rapist, my on the record rapist, $1,785 a month when they know I was not working last year. Where are they coming up with those numbers? So, the judges will finally give us what we want, but then they're going to hurt us in the process. So, Dave Weigel is finally divorced, but now ordered to pay an insane amount of money per month, a ridiculous amount of money a month. Yeah. And it's just disgusting. It's absolutely disgusting what these people are doing to us U.S. citizens. Yeah. Taxpayers absolutely have a reason to be concerned. This may not directly affect you, this family court corruption and illegal activity. This may not directly affect you, but you're paying to support it. You're paying to support these judges walking all over our constitutional rights. Mm-hmm. And it may not be you, but I guarantee someone you love or you know or you work with is having it happen to them. Mm-hmm. So taxpayers absolutely need to be aware of what these judges are doing to us. And when it comes time to vote them out, use your voting rights to vote them out.
Always
stop paying their paycheck to hurt us as citizens.
There's generally, anytime you see a judge's name up, they've got it set so you have to. The wording here in Florida is should Judge so and so be retained. It's not should they be reelected. It's like we're going to let them stay unless enough people tell us not to let them stay. You have to
actually vote them out, otherwise they continue hurting us as citizens.
So this is my public PSA for tonight. Next time you vote, if you don't know the judge is good 100%, do not vote to retain them. Vote for them to be kicked out of office. Here's the thing: if they're good, they'll be able to come back. But so many of the judges across this country are just blatantly bad for the general public.
Yeah. They are not in it for the reasons they should be.
That's the nicest way I can say that.
They are not following their canons, their oath, their ethics. They are absolutely hurting us as humans. And the only way to get this to stop is to continue spreading the knowledge of what's happening, share our stories, and educate yourself on what these family courts are doing to us across this country.
And on that note, we're gonna close it off here. So remember, pay attention, look out for the Disrupt the Corrupt podcast and the Support Isn't Silent podcast. Heather will post all of the links as soon as those episodes go live. But we're looking forward to sharing some stories, and we want to thank everybody that watches this video, everybody that saw it live, everybody that watches the recording. We appreciate your support, and we hope you find some level of peace in knowing that you're not alone.
Yep. And to my 4 children, Ariana, Tommy, Bianca, and Charlie, I will continue to fight for justice for all 5 of us. They cannot hide behind the lies forever. They cannot hide behind the illegal activity forever. I will be getting this to Illinois and Florida Supreme Court, and I will be filing in U.S. District Court to fight for our constitutional rights. Your rights are being violated as well. You are being hurt as well. You just don't know it because you are being lied to by Justin, Mary, and Ira Serlick. They are your abusers, and I will continue to fight this abuse. I love you, I miss you, and I will continue to use my words on legal paper to fight for us. Have a great night, everyone. Thank you for listening.